So can everyone hear me all right? Great. Good evening, ladies and gentlemen. My name is John Skidmore. I'm the Director of the Criminal Division for the State of Alaska Department of Law. What that means is that I oversee all the state prosecutors in the state. And what I wanted to do is to help you understand stand your ground law as it's passed in Alaska. I think you're going to find that that's actually different from what many other states have done. I'm not going to discuss a lot of what other states have done. I believe that the professor's going to do that for us a little bit later. But I'm going to try and go through first and present to you what the self-defense laws in the state of Alaska look like prior to the stand your ground law that was passed in this last legislative session. And then I'm going to talk about the change that occurred. Now what you're going to find is that most of my presentation is simply trying to explain how self-defense looks in Alaska, because the actual change that the stand your ground made was a very minor one to our statutes. But I want you to understand the full scope of the statutes so you can appreciate what that change was, and then that'll put you in a better position as well to compare what we have in Alaska with what the professor's going to tell you about exists in other states. So, if this is set up properly, we'll find out here. All right. So the first thing that I want to start with is the self-defense law. As I indicated, it's prior to September 18th of 2013. That's when the stand your ground went into effect. So literally just a matter of 1.5 months ago. That's as long as stand your ground has been in Alaska thus far. So what I'm going to start with is the statutes that predated that, and I've listed those statutes up there for you. Alaska Statute 11, Chapter 11, 81 through 330, and 1181 through 430. And I'm going to start with non-deadly force. In Alaska, we separate self-defense into two categories: the use of non-deadly force and the use of deadly force. So I'm going to start with the use of non-deadly force. And the statutes, some of these will be the exact wording of the statutes. Some of the other slides that you can see that I have up here this evening are sort of a summary of the statutes, because if you actually look at all the wording that the legislature puts in, sometimes it gets a little confusing, and I've tried to boil it down to its essence. What this one says is that a person may use non-deadly force upon another when and to the extent that the person reasonably believes it is necessary for self-defense against the person reasonably believes to be the use of unlawful force by another. And then there are exceptions. I'm not going to come back to those exceptions, but first I want to take an opportunity to explain the language that you see in front of you right now. I'm going to start with what force means, because when you talk about self-defense, or when you talk about assaulting someone, in Alaska, the law talks about those actions as force. And force means any bodily impact, restraint, or confinement. So we're talking about a punch, we're talking about a slap, we're talking about if you pick up a piece of wood and you swing it at somebody else, we're talking about if you pick up a knife, we're talking about if you have a gun, any force, all right, any bodily impact, restraint or confinement. So if you have somebody in a chokehold, if you put them in a bear hug, that's restraint, that's confinement. That's what we're talking about when we talk about force. Now, I'm going to come to deadly force in just a moment, and we're going to differentiate between just typical force and then deadly force. The other things here is that it can also be the threat of an imminent bodily impact, restraint, or confinement. So if I have a firearm and I pull out that firearm and I point it at somebody else, even if there is no impact, there is no bullet shot from that gun that actually impacts somebody else's body, it's that threat can also be considered force. If I walk up to somebody, I'm in a bar, and I get into an argument with them, and I raise my fist like I'm getting ready to hit them, that's a threat of force. And that's what this is also talking about when we say force. It includes that threat of that bodily impact. And force can be deadly or non-deadly. So we're going to go on from there, and I'm going to talk about what deadly force is. Deadly force is force with the intent of causing, or under circumstances that one knows creates a substantial risk of causing, death or serious physical injury. Again, we're talking about deadly force here. So it's when you are exercising that force against somebody else, and you're doing it with the intent, the knowledge. You know, and it's your intent, your objective to cause substantial risk of death or serious physical injury. Now, what this also means is it's the intentional discharge or pointing of a firearm in the direction of another person. And it can also be when you're pointing it in the direction of another person and you simply want to create that fear of physical injury or by means of a dangerous instrument. I'm not going to go through and define every term here, but for instance, a dangerous instrument includes things like a knife. So when I spoke before about threatening someone with a knife, that's how it's defined in this as well. I'm not going to go through every statute, but that kind of gives you the general gist of it. So force is any bodily impact. But to become deadly force, it has to create the risk of serious physical injury or death. Makes sense? Now, the other thing that you have to keep in mind is that in the statutes that describe self-defense, you're going to see this word reasonable. It's repeated over and over and over. And that reasonable belief, one of the important things about it, is that a reasonable belief is the belief of a sober person. Someone who is not under the influence of drugs or alcohol. And this is important because when we start to talk about self-defense, and I'm going to get to this in a moment, there is both a subjective and an objective aspect of self-defense. So here's that statute again, and I want to talk about that. When a person uses non-deadly force, when and to the extent the person believes it is reasonably necessary, and that's that reasonable part. So let's explain what that means. In order for someone to claim self-defense, you have to have the objective, the reasonable, sober perception of an imminent threat. That's the reasonable person has to say, in those circumstances, it would have been reasonable to believe that someone was going to use force. So if I'm sitting on the ground and I say to somebody else, boy, you know, you really upset me, and gosh, that makes me want to do something to you. It makes me want to hurt you. But I'm sitting there, I'm kind of twiddling my thumbs, and I haven't said a lot about it. Does the reasonable person think that I'm actually threatening the use of force against somebody else? I submit to you the answer is usually no. Whereas, if what I'm doing is I'm in a fight, or I'm in a bar, and I'm screaming at somebody, and I'm raising my fist like I'm going to punch them, now does the reasonable person think that there's a risk of harm or a use of force in that circumstance? So it's that reasonable person. Then the second one you see up there talks about an actual belief. And what that means is that for a defendant to claim self-defense, there has to not only be the objective standard that the reasonable person would think that was going on, but the defendant must also have the actual belief of that. So it's a subjective belief. And you're going to see this repeated through the next elements that I list up here. The next one is the reasonable, sober belief that the force is necessary. So in other words, let's go back to that bar incident. And in that bar incident, you got one guy on one stool, and he's been drinking alcohol, and you got the other guy on the other stool, and the guy that's the first one that's there, and he's saying to him, you know, boy, I'm gonna mess you up. I'm gonna do something to you. And he's staggering around, and he falls over flat on his face. Okay, did you actually need to use force to protect yourself in that circumstance? Or let's take another scenario. In that situation, you have somebody else that comes up and is holding that person back. Now, I, as the person who would be the victim, the one that he's saying is going to use force against me, and somebody's holding him back, do you think it's appropriate for me to walk over at that point and punch that guy while he's being held back? Is it necessary for me to engage in that action? And that's what that next part talks about. When and to the extent it's reasonably believed to be necessary. That's what the statute says. So the objective person has to think that it was necessary, and the defendant, the subjective, also has to believe it was necessary. Now we're going to go to that next element, and this one talks about the amount of force to be used. And again, we start with the reasonable, that sober person. And it's the amount of force to be used. So back to that bar situation again. That's a good analogy. You've got one person who throws a punch, and he's about the same size as I am, and he throws a punch at me. Now, what's the amount of force that's appropriate there? Force can include like pinching someone. So let's say I walk over, that's bodily impact. I walk over and I pinch him. Well, is that an appropriate amount of force for me to use in response? Some people might say I need to use more. The question is, should I use less? Pinching, is that okay? He punched me. Probably. He punched me, I punch him back. Is that okay? Yeah, probably is. He punches me, same size as me, no indication the guy's trained in martial arts, and I pull out a gun and I point at him. Now, did I need to do that to stop this? Was that necessary? Now, that's a question for the jury. That's something the jury has to answer. And these are all questions that are presented to the jury. But that's how the analysis works. Did the reasonable person think that the amount of force was necessary? And does the person who used it actually believe it was necessary as well? So I'm at trial and I've charged somebody with assault and they claim the defense of self-defense. And he takes the stand and I'm going to cross-examine him. And I ask him, did you think you actually needed to pull the gun? Did you think you needed to pick up that bar that was on the ground? Did you need to pick up that bottle and hit him over the head with it? Is that what you thought you needed to do to protect yourself? And he says, no, I didn't need to do that. I was just really angry. He has just said he did not act in self-defense. Self-defense is saying that the amount of force was justified. It's called the justification defense. So does that make sense? All of that is self-defense. And those elements existed prior to stand your ground. They still exist today. Now I want to go on and I want to talk about the exceptions to self-defense, when you cannot claim self-defense. The first one is mutual combat. So you got two guys and they both decide that they're going to kind of box it out and punch each other, and no one's the initial aggressor. This is just mutual. They decided they were going to do that. Okay, self-defense doesn't apply. Another guy gets to say, well, I was just defending myself. No. You agreed you were going to do this. That's what mutual combat is. The next one is that you provoke the other person with the intent to cause serious physical injury. So what that means is, if I'm the person that wants to claim self-defense, I don't get to go to another person and say something to them or engage in some action that I think will upset them and cause them to want to use force against me. So, this is a minority task force. Let's put that into real terms. You don't get to go to somebody else and make a racial slur. And then when that person wants to haul off and hit you, you say, hey, I was just defending myself when I hit him back. Nope. You don't get to claim self-defense in those circumstances because you did something with the intent to provoke with the intent to cause physical injury. You were provoking the person, and that doesn't allow you to claim self-defense on that. Okay? That still exists as well. The last one is the initial aggressor. So the initial aggressor, this exception to self-defense is a situation where you got two folks and you have to figure out, well, who started? Who's to blame? Not mutual combat, but one person was really the aggressor in that situation. They were really getting in the other person's face. They were the one that picked up their fist first. They were the one that picked up that gun first. Whatever it is, initial aggressor. Whoever is the initial aggressor does not get to claim self-defense. The person who is not the initial aggressor does. So, in the courtroom, when we charge somebody with assault and somebody wants to claim self-defense, you bet I responded. I was punching everything. I did that because that other guy was the initial aggressor, not me. And if I can't disprove that, then they get that self-defense claim. That the jury would find that person not guilty. All right. So initial aggressor, the person who wants to claim self-defense cannot be the initial aggressor. Now, there are some other exceptions that were added a little bit later. Those were the initial exceptions. These are some other exceptions. These were in existence prior to the stand your ground law that passed us here. This one talks about that if you possess a weapon or a dangerous instrument while in the furtherance of a felony criminal objective. What does that mean? Well, that means that if I possess a firearm and I want to claim self-defense, I don't get to claim self-defense if I possess that firearm while I was in furtherance of committing a felony. So I'm going to commit a theft. I'm going to go and I'm going to steal someone's purse or credit card and it's worth a certain amount of money that makes it a felony. If I'm in possession of a firearm while I do that, and for some reason during this theft there's an altercation that occurs, I do not get to claim self-defense because I possess a dangerous weapon in furtherance of a felony offense. Now the next one is a participant or in flight from a felony drug offense. So what that really means is that if you have two individuals that are engaging in a drug transaction, and one of them has brought a firearm to that drug transaction, and for whatever reason during that drug transaction, things go bad, and there ends up being an altercation, there ends up being a fight, an assault. Even if I am let's say I'm the dealer, and somebody comes to buy drugs from me, and then they decide they want to rip me off. And I want to respond with self-defense, because I say, hey, the other guy, he was the one that was the aggressor towards me. I was just defending myself. The law says if you're committing a felony drug offense, you don't get to claim self-defense. Okay? Revenge or retaliation. This is known as the gang exception. And what this says is that if you are acting in response to an actual or perceived conduct by a rival or perceived rival or a member or perceived member of a rival group, and if that rival or group has a history or reputation for violence, you don't get to claim self-defense. These are all just exceptions. All of these things existed prior to the Stand Your Ground law. All of these things exist after the Stand Your Ground law. Reasons you don't get to claim self-defense. Now, we get to something called withdrawal. And in the statutes, what withdrawal means is that if I'm in an altercation and I decide, or I'm in a situation that hasn't developed to an altercation, and I say, you know what, I don't want to do this anymore, and I want to walk away from it. Even if I was the initial aggressor, even if I was the one that was getting in that other person's face, if that other person runs after me, now I can defend myself if I withdrew. And what it means is you withdraw, you effectively communicated your withdrawal, and the other person persists in continuing the incident with the use of unlawful force. So if I walk away and the other guy runs after me, I am now justified to use self-defense, even if I was the initial aggressor in the beginning. I walked away. That hasn't changed under this. This has not changed under Stand Your Ground either. Now, deadly force. I want to talk about deadly force for a moment. First, you have to have been justified to use non-deadly force. That whole bit about when and to the extent reasonably necessary, the amount of force you use. This repeats when and to the extent the person reasonably believes the use of deadly force is necessary for self-defense, and it has to be against a specific act, and those acts are listed out in the statute. You can only use deadly force if you are protecting yourself from a threat or the amount of force that could cause death, that could cause serious physical injury, that's a kidnapping, sexual assault of the first or second degree, any degree of sexual abuse of a minor, any degree of robbery. Those are the only times that you are authorized to use deadly force in self-defense. Now, I'm going to come to defense of property in a moment, and we're going to talk about when deadly force is allowed there. Right now, I'm just talking about injury to a person. We're not talking about property, just to a person. Only use deadly force in responding to one of those circumstances. If it's not one of those, it's not justified. All right? So, that goes back to that extent that it's appropriate. Let's go back to that bar example. I threatened to punch somebody else, and you pull out that gun and point it at me. This law says that amount of force was inappropriate. It was too much. This still exists even after the Stand Your Ground provision. Duty to retreat. This is what has changed. So let's talk about duty to retreat prior to Stand Your Ground. It says you may not use deadly force if the person knows with complete personal safety and complete safety as to the others that are being defended. You can avoid the necessity of using deadly force by leaving the area of the encounter. That's what the law used to say. So I'm in that situation, and the person is threatening me with a gun, is threatening me with a knife, is going to run me over with their car, is, you name it, whatever that force is, whatever that bodily impact is that they're threatening against me or are actually trying to use against me, whatever that is, if I could have previously walked away with safety, I was required to do so. So, to finish off the chart we were talking about before, self-defense, the defendant cannot be the initial aggressor, the defendant cannot provoke the conduct with the intent to cause physical injury, the force cannot be the product of mutual combat, and if a defendant cannot have been able to retreat with complete safety, if they could have, they don't get to claim self-defense under the previous law. Now, under the previous law as well, there was no duty to retreat for a number of circumstances. These were additions that were added probably in the last 10 years, but these were in the statute before the Stand Your Ground was passed this year. There's no duty to retreat if you are on premises that you own or lease, if you are in a location where you reside, whether temporarily or permanently, if you are a guest, whether or an express or implied agent of the owner, lessor, or resident. This is sometimes known as that castle doctrine. You're entitled to protect your own home. And there's no duty to retreat for your own home. This was expanded slightly, but it's still the same idea. Don't have to retreat from your own home. Okay? No duty to retreat there. A peace officer, if acting within the scope and authority of their employment, or if a person is assisting a police officer in the scope of their employment, there is no duty to retreat. An officer is not required to walk away if they could have with personal safety. Why? Well, officers have the obligation to assist others, to enforce the law. And if we said they could always walk away with personal safety before they use force, that would mean that an officer couldn't use force appropriately in the scope of employment. So the duty to retreat doesn't apply to an officer. There's also no duty to retreat if you are in a building where you work and it's in the ordinary course of your employment. So you're at work and somebody comes up to you and they're threatening you with some amount of deadly force and you could walk away safely, but you're at work. You're not required to retreat. No duty to retreat under those circumstances. This was prior to the Stand Your Ground law being passed. Protecting a child or a member of the person's household. Also prior to the duties, also prior to Stand Your Ground, there's no duty to retreat if you're protecting your kid or somebody else in your house. No duty to retreat under those circumstances. All right, now let's talk about defending a third person. And that last example of no duty to retreat applies to this as well. But there's a different statute that actually talks about defending a third person. Everything I've talked about so far was defense of yourself. This is defense of another person. It's the same idea, you just sort of add to it that that other person would have had the duty to act in self-defense. That's really all this law says. If that person would have been entitled to act in self-defense, you're entitled to defend them as well. Now, property. Property or premises. And this gets a little complicated. I'm going to go through different types of property crimes. Theft or damage of property. You don't get to defend the theft or damage of property generally with deadly force. You can only use non-deadly force. Again, it's when and to the extent that the person reasonably believes it's necessary to terminate what the person reasonably believes to be an unlawful taking or damaging or attempted taking or damaging of property or services. And there's no duty to retreat. Why? Because the duty to retreat only existed for deadly force. Here, it's non-deadly force. No duty to retreat. You can only use non-deadly force if you think someone's trying to steal or damage your property. As to arson, well, for arson, you get to use deadly force. You're setting fire to a building, and this goes a little beyond that. It also has to be upon a dwelling or an occupied building. And I won't go into all the reasons, but there's different degrees of arson. You can actually commit arson on a building that's not occupied. What this is saying is, you don't get to use deadly force to protect an unoccupied building unless it's a dwelling, somebody's home. But if it's somebody's home, or it's a building, a place of work, a place of business, and there are people inside of it, you get to use deadly force to protect it. And there is no duty to retreat under the law prior to Stand Your Ground when you're protecting against arson. Then we go to trespass. And there's a couple different degrees of trespass. I'm not going to go into all those details, but essentially you're in possession or control of the premises, either as a guest, as an express or implied agent, and it's non-deadly force when and to the extent reasonably believes. It's that same language you've heard before. And trespass. Trespass is you show up someplace that you're not allowed to be and a person's told you to go. Whether it's a business or a residence, you only get to use non-deadly force to defend against a trespass. Burglary, on the other hand, you get to use deadly force. If it's burglary of a place that is occupied, dwelling, or building, it's the same idea we talked about for arson. Here you get to use deadly force, but it's got to be because you're essentially protecting another person, because there is someone that is in the dwelling or in the building. And under the law as it was before, again, no duty to retreat for this. Carjacking. That's when you're actually in the car and you are being physically pulled out of the car, or you're still in the car, and for that, you're allowed to use deadly force upon another person to prevent the carjacking. So somebody doesn't get to come up to you at the stoplight and try and pull you out of the car. You get to use deadly force, and there's no duty to retreat. You don't have to try and drive the car away. You get to use deadly force right then and there. That's the way the law was before. That's the way the law still is now. Then we go to vehicle theft. This is if you're already outside the vehicle. You're not in the vehicle. You're outside the vehicle and somebody's trying to steal it. What do you get to do? Well, you get to use deadly force, but only if there's somebody inside the vehicle. Again, it's that theme of protecting someone. And this is that idea that, you've gotten out of your vehicle, you run into the store, and maybe you got your kid that you left in the vehicle or whatever else. Somebody tries to steal it. You get to use deadly force to stop them from doing that, so long as there's somebody else in the vehicle. Okay? No duty to retreat on that one either. There are other justifications for when you get to use force. And I don't want to go through all these. I just want to make people aware that these justifications exist for the use of force. Peace officer in making an arrest or terminating an escape. Use of force by a private person in assisting an arrest or terminating an escape. The use of force by a private person in attempting to make an arrest or terminating an escape. The use of force by correctional guards in the performance of a public duty and in special relationships. We don't need to go into all of that. None of this was affected by stand your ground. Just other reasons in which people were justified to use force. Okay? Now, stand your ground. House Bill 80. It passed in this past legislative session, which means that was back in February or March. The governor signed it sometime this summer. It went into effect September 18th of 2013. Less than 2 months that it's been in effect thus far. And the only thing that addresses, in all of that stuff that I just told you guys about, the only thing it addresses is the duty to retreat. Let me make clear, when we talk about stand your ground, you will hear that term used in the media. You will hear that term batted about for what other states do. I'm talking to you about what stand your ground in Alaska means. It can mean something different in other states. So if we go back, this was that duty to retreat. And you remember we went through all of this part where we described what the duty to retreat was. We described the exceptions when you're on premises, if you're a peace officer, in a building where the person works, or you're protecting a child. Here's what stand your ground did. This is the only language that you have no duty to retreat in any place where a person has a right to be. That's it. That's the full extent of what they add. Now, what does that mean? Any place where you have a right to be. Well, if I'm walking down a public street, I got a right to be there. If I'm trespassing, I don't have a right to be someplace if I'm trespassing. If I'm committing a burglary, I don't have a right to be there. If I'm at work, I have a right to be there. If I'm in a store that's a public store that's open to the public at that time, I have a right to be there. If I'm in my home, I have a right to be there. If I'm in my car, I have a right to be there. You get the idea. That's what this says. That was the change in the law. So if we go back to this chart that I was describing before that talks about how we defend against self-defense, and let me say a few more words about that. In a case, if I want to charge somebody with assault, if I want to charge them with murder, whatever the case may be, whatever I'm going to charge them with, and they say, I'm going to claim self-defense, they're required to give me notice of that prior to the trial, 10 days prior. That's what the rule says. Whether or not courts actually make people follow, that's a whole other story. But they're supposed to give us notice. And when they give us notice, what happens at the trial is, as the prosecutor, my job, the people that work for me, the prosecutors, their job, is to disprove self-defense. So if the other person says, hey, I was entitled to use self-defense, I have to show that that's not the case. So what this chart does is it shows you different ways, different tactics that we can go about showing that the person wasn't acting in self-defense. Again, a reasonable, sober person's perception that there was an imminent threat has to be right now. It can't be based on past events. It can't be something that happened yesterday. It can't be something that happened 2 weeks ago. It's got to be right now. An imminent threat. A reasonable person has to think that, and the person who's charged has to actually believe that as well. If I can disprove one of those, this person doesn't get to claim self-defense. But the burden is on me to disprove it. 3 and 4, the reasonable sober belief that the force is necessary, and the person actually believes that the force is necessary. Is it necessary? Again, that's a question for the jury. But is it necessary? Those things still exist. If I can prove it wasn't necessary, then I prove this person was not entitled to act in self-defense. This use of force was not justified. That's what the law is about. 5 and 6, the amount of force. Not just that it was necessary, but also the amount of force was appropriate. It goes back to that example of if somebody punches me, how much force am I entitled to use in response? What if I punch them and let's say I worked out a lot more than I actually did with that one punch, drop this person to the floor? Do I get to start kicking on them? Is that amount of force necessary? That's what the law talks about. Does the reasonable person think that that amount of force was appropriate? Does the person who's using force actually think that that amount of force was appropriate? None of that's changed. All of that's the same. So let's go to the next one. Initial aggressor hasn't changed. That the defendant cannot provoke the conduct with the intent to cause physical injury hadn't changed. That the force cannot be the product of mutual aggression hadn't changed. What's changed is that last one, the 10th one, the one that I underlined. I no longer get to argue that the defendant cannot have been able to retreat with complete safety. It's pretty much, if you're in a place where you're entitled to be, you get to claim self-defense. Okay? That's the sum total. So, in Alaska, if I have someone that commits what I think is an assault or I think is a murder, if I, as the prosecutor, think, yeah, I think that crime has been committed, and I look at it and I say, you know what, I think this person's going to claim self-defense at trial, but I think I can disprove it, I get to file those charges. In other states, like in Florida, Trayvon Martin, all of that media, a lot of what that was about is whether or not the prosecutor actually gets to bring the charge at all. Stand Your Ground in other states, not all of them, but in some of them, says you don't even get to file the charge under those circumstances. In Alaska, we say the charge can be brought, the evidence can be presented to the jury, and the jury gets to decide. There is no prohibition against us bringing those charges initially that exists in other states. Okay? So, again, stand your ground. When I say that what's meant by stand your ground in Alaska is different than in other states, that's one of those aspects. So, I can't tell you what every other state stand your ground law means. I can't tell you how many states have it. I think the professor's going to talk about some of those things. I can't do those things for you. I can only tell you that in Alaska, I've explained what the law of self-defense is, House Bill 80, which was enacted. I told you how House Bill 80 changed it. Not in a very big way. Is that different from what it was before? Yes, there are some differences. Will that make jobs of prosecutors a little bit more difficult in some cases? It may. But that's the law that the legislature passed, and our job as prosecutors is to enforce it and follow that law. So, that's the presentation on self-defense for Alaska. I'm going to turn it over to the professor so that he can talk to you about what other states have. If you all have questions about the law of self-defense in Alaska or how it affects trials or anything that we're going to be doing, please write those questions down, pass that paper along. Those papers will get to Ms. Parks, and she'll be able to read those and hopefully be able to ask us some of those, and that's when we'll answer questions later. Okay? I thank you for your time and attention. I hope this has been helpful explaining the self-defense law in Alaska and how the Stand Your Ground bill that was passed this year has changed.